of law is? Oh, there we go. Continue. So one key hint here is process. That makes us think of procedure, right? Trial procedure, the ability to cross-examine a witness, to have an impartial jury. This is sort of obvious due process, okay, procedural rights. But the Supreme Court has also read this to mean not just procedural due process rights, but substantive due process rights. And this is a very weird concept. Not all Supreme Court judges like this, but substantive due process we're going to be talking about as opposed to procedural. So substantive is more like a substantive right. For example, the right to terminate a pregnancy. Okay, that's a substantive right. The right to for two consenting adults to marry each other. That is a substantive right under due process under the 14th Amendment. Okay, we're going to get into that more. We've got a list of all the substantive rights coming up here, but I just want to give you that quick view of that. Now, equal protection is slightly different. Equal protection has to do with discrimination. So discrimination based on race, religion, color, national origin, and sex. Race, where am I? Religion, color, national origin, and sex. Okay, there's really 5 categories that are protected under the Equal Protection Clause of the 14th Amendment. Okay. So notice what I'm not saying there. What categories am I not saying that maybe you think should be in there? Maybe sexual orientation or gender identity.
Yeah.
Okay. So just those 5. We'll talk more about sexual orientation and gender identity later. Okay, so this is 14th Amendment, most litigated, our biggest legal vehicle for civil rights laws. Now there's also the 5th Amendment. Okay, this came very shortly after, well, at the same time the Constitution was ratified, because the Bill of Rights was sort of contingent on ratification of the Constitution. We see similar language in the 5th Amendment, right? No person shall be deprived of life, liberty, or property without due process of law. We have that same due process language here in the 5th Amendment. And so the 5th Amendment applies to federal government action. Remember, 14th applies to state. So there's one of our dichotomies: state action versus federal action. Okay. So the 5th Amendment is the legal vehicle for civil rights laws as they pertain to the federal government, not the state government. So what's missing, though, from the 5th Amendment if we're kind of mirroring the 14th Amendment? We've got due process, but what are we missing here?
Equal protection.
Yeah, equal protection. So when the Bill of Rights was passed, what was that, maybe 80 years before the 14th Amendment, there was no concept of equal protection, but the Supreme Court over the years has sort of interpreted the due process clause of the 5th Amendment to also mean equal protection. So through judicial interpretation, we also have an equal protection clause in the 5th Amendment, okay? Even though it doesn't say. And there's a lot more to the 5th Amendment, not necessary to discuss for our purposes. Another legal vehicle is the Ninth Amendment, the lonely kind of stepchild of the Constitution. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So this is sort of a catch-all that says, look, we've listed some rights here in the Bill of Rights, but just because we listed them doesn't mean that this is an exclusive list. There's others out there we haven't listed. Okay. We'll get a little bit more into the Ninth Amendment later. Not commonly used, I will say, though, the Ninth Amendment, and it's sort of frowned upon to use it. The last time it was really used was Roe versus Wade, which is part of the reason it's sort of frowned upon.
Oh.
Okay. So remember I was talking about substantive due process rights under the 14th Amendment and equally under the 5th Amendment, depending on if it's state or federal action. Well, the Supreme Court really beginning, I mean, you could say in the 1940s, started interpreting the 14th Amendment and that due process clause to mean that there are also substantive rights. Again, this really started during World War II, ever so slightly before, and really took off after World War II. And the court decided, okay, well, how are we going to incorporate rights listed in the Constitution into this due process clause? So let's think of a right listed in the Constitution. Can anyone think of one?
The right to bear arms.
Perfect example. Okay, so that is a right actually explicitly listed in the text of the Constitution. And so if someone decides to litigate and say, oh, my right to bear arms has been unconstitutionally infringed, they are going to sue, and let's say it's infringed by a state law that was passed. They're going to sue under the 14th Amendment and the Second Amendment, right? Right to bear arms comes under the Second Amendment, but they first need that legal vehicle of the 14th Amendment of due process. And so courts thought, okay, well, should we just say all the rights listed in the Constitution are going to be substantive due process rights, or should we go piecemeal one by one? And they came down on the latter of that decision and said, okay, we're just going to do piecemeal incorporation. So every time we've got to have cases come before us where litigants are making claims that each of these rights have been infringed. So it took even until just a couple years ago we're still going through the rights in the Constitution and determining if they are protected under due process or not, okay? And remember, we're not talking equal protection here. There's no discrimination here. These are substantive due process rights. And so over the decades, courts have had cases come before them and say, okay, yes, the right to bear arms, that's a substantive due process right. And so we're going to call them fundamental rights. Okay, fundamental right. Now, just about every right listed in the Constitution has been declared a fundamental right, partially because it's listed in the Constitution, except two of them. And right to bear arms was only 10 years ago, 12 years ago that was declared a fundamental right, strangely. Can anyone think of what two rights that are listed in the Constitution have not been declared fundamental?
Abortion.
Well, abortion is not listed in the Constitution.
Right.
So I'll just tell you. I thought maybe some of you might know. So the first one is the Third Amendment. And that's just because it's almost never litigated. That is the boarding of troops in homes.
Oh, yeah.
Okay, so it's just, in the 80s, there was a case out of New York and it got to a federal appellate court, but it stopped there. And that's, I think, maybe the one and only, maybe the second time it's been litigated. So the Third Amendment, it's just kind of a non-entity. No one really talks about it, that right hasn't been infringed. But the really important one that has not been declared a fundamental right is the Seventh Amendment, the right to a civil jury trial. Believe it or not, the right to a civil jury trial. Why do you think that is? Why do you think civil jury trials are not fundamental, not important?
Possibly because sometimes don't you have a choice of a jury or a judge?
Okay. Oh, I like that answer. I haven't heard that one. You are correct. You do have a choice, but you still have the right. You still have the choice, right? Think about our modern times, when you buy something online and you're kind of clicking on terms and conditions. You say, yes, I approve. What do those terms and conditions usually always contain?
Disclaimer.
Yeah. So private arbitration. Okay, no judge, no jury, not public, confidential. And I see something in the chat here. Yes, Mary, I'll put a copy of the slides in the chat. So that's really, at this point, that's really the only right listed in the Constitution that has not been declared this fundamental important right. And we'll discuss why it matters whether you're fundamental or
Hey,
not.
honey, how are you? I'm good. Good.
Oops,
It turns
sorry.
out there's a
I'll mute her. Okay.
Okay.
Good.
And we'll get to that later. I know you're probably wondering, but I just kind of want to get this basic concept down first.
Mhm.
Now, there are rights that have been declared equally fundamental that are not listed in the Constitution. And here is a list of all of them. That I can think of. So marriage, recently with at least same-sex marriage that has come about. We saw that in the 1960s with Loving versus Virginia, which is now a movie about mixed race marriages. Keeping the family together, taking children away from their parents, procreation, so the right to not be sterilized, essentially, the right to have as many children as you want. Purchase and use contraceptives, abortion or terminate pregnancy, to refuse medical treatment, private consensual sex, okay, as opposed to public, to travel, accessing courts, custody of children, parents to control child rearing and education, self-defense, which we saw most recently in the Second Amendment cases from 2010 and 12. And there's one other here that I didn't list, which is really appropriate for the League of Women Voters, but what is another right not listed in the Constitution, another fundamental right?
I was going to ask about voting rights because we hear
Yeah.
about voting rights, but okay, that's a fundamental right.
Yeah, and it's odd in the Constitution if you look at, say, and I'm blanking on the number of amendment, but the amendment that gives women the right to vote.
Oh, the
It says,
19th.
yeah, the 19th. Thank you. the the vote shall not be abridged on the account of sex, or something like that. I should quote it exactly. But it doesn't say specifically that there is an actual right to vote.
Mm-hmm.
Okay, amendment, and I've got my little Constitution booklet here. You know, it actually does say that the right of citizens of the United States to vote shall not be denied or abridged by the United States. This right to vote that's a fundamental right here, speaks more to one person, one vote. And that's where the Supreme Court case law comes from.
Okay.
So those are the unlisted fundamental rights.
And then, you know, when you just read that, you said shall not be prevented by the federal. What about the states?
Shall not be denied or abridged by the United States or by any state.
Okay, good.
On
good,
account
good.
of sex.
Okay, good.
Okay. Oops, I do want to go back there. So before we get into rational basis scrutiny, how do courts decide what is a fundamental right versus not a fundamental right? How do courts decide to give more importance to certain rights than other rights? Is there some sort of rule book or test they use to say, okay, abortion, yeah, that counts. But for example, physician-assisted suicide does not count. So here's the test that they use, and quote, those principles of justice so rooted in the traditions and conscience of our people, end quote. Or, quote, principles of liberty which lie at the base of our civil political institutions, end quote. That's it. That's how they decide which rights are more important than other rights. So you can see why nominating and voting for a Supreme Court justice is quite important, at least in the arena of civil rights. I mean, this gives an extreme leeway to any judge to decide which rights are more important than others, okay? And you'll find this a lot in law of any kind, just really vague tests that are out there, okay? So judges do matter. Okay, now let's get into scrutiny. And this is really where people are fighting, where lawyers, advocacy groups are fighting. So when judges are presented with a claim that a right has been infringed, they first have to decide, okay, is this a fundamental right or not? Okay, and remember those tests for fundamental rights, okay, very vague. If it's a fundamental right, they get a higher level of scrutiny. If it's not a fundamental right, they get a lower level of scrutiny. And scrutiny is the test that a judge will use to decide if the government can infringe on the right or not. And there are 3 levels. Here's the first level, rational basis scrutiny. This is the lowest level. Okay, these are non-fundamental rights. Okay, the non-important rights. These get rational basis scrutiny. And here's the test. Here's the legal language that courts use. And we'll go through some examples. So a court will invalidate a law unless the government can prove that the purpose for the law is legitimate and rationally related to that purpose. The key words here are legitimate and rationally related. Okay. So really, if your claim is deemed not fundamental, not worthy of heightened scrutiny, you're likely going to lose, and the government is likely going to win, because just about any law can have a legitimate purpose. And just about any law would be rationally related to that purpose. It doesn't have to be the best connection to that purpose. There could be better laws that could be written out there, as long as there's some logic behind it, okay? Legitimate purpose of government is just about anything. They can legislate on just about anything. So it's hard to find something that isn't legitimate. Let's say the government decides that it is not going to, and the federal government is not going to give Social Security benefits to anyone who wears red hats. Okay, weird law, silly, no government would pass that law. But it's possible the court could say, well, deciding who gets Social Security benefits and who doesn't, and administering that Social Security program, welfare program, that's a legitimate purpose of government, okay? Now, is it rationally related to that purpose, saying people who wear red hats can't receive benefits? Probably not rationally related. The government might actually lose, okay? Here's another example. Let's say you've got a city. So this is state or local government, 14th Amendment. Let's say the city creates a zoning ordinance that says, you know, in this neighborhood, in this zone, we're only going to allow single family dwellings. Okay. Is that a legitimate purpose of government? Sure. Zoning. All governments do that, except for Houston, I hear.
Right.
And so what would the purpose of that law be? So the government might claim, well, the purpose is to prevent density or preserve historic buildings, or just, who knows, they can come up with really anything. And so would that be rationally related to, would creating single family dwellings be rationally related to preserving the historic nature of the buildings in this neighborhood? Sure. It might not be the best way to do it. It might not be, there might be better ways to ensure this, but it has logic behind it. Okay, we judges, we're not really going to question that too much. Okay, there's logic behind it. So if someone were to sue the city and say this zoning ordinance discriminates against people of color by only allowing single family dwellings and not multi-unit dwellings, that adversely impacts people of color, it's discriminatory. The court would say, well, look, there's no intent here. It has a legitimate purpose that's rationally related. So there's that rational logical connection, okay? That's rational basis, lowest level of scrutiny. Government is usually always going to win this one. Okay.
Because housing is not a right, right? Is that another? There's no right to housing right
True.
now.
Under the Constitution, true. Okay. Under the Constitution, true. Okay, let's move on to strict scrutiny. Okay, so rational basis is our first level. It's the lowest level. The highest level is strict scrutiny. So fundamental rights are going to get this test in court. Discrimination, and intentional discrimination based on race, color, religion, national origin, and just those four, not sex. We'll get to sex later. So just those four, plus fundamental rights, are going to receive strict scrutiny. This is what everyone is fighting about behind the scenes, especially with LGBT rights. Okay. Is discrimination based on sexual orientation worthy of this heightened strict scrutiny by judges? So let's take a look and read it. So a court will invalidate a law unless the government can prove that the purpose for the law is compelling. So not just legitimate, like rational basis, but compelling and narrowly tailored to achieve that purpose using the least restrictive means possible. So not just rationally related. It has to be extremely narrowly tailored to achieve that purpose with no unintended consequences. Okay? It's got to really be the best policy out there to achieve that compelling purpose. Okay? Judges will consider other policy alternatives, which might sound scary to your ears, but they will consider other policy alternatives and say, well, is this policy better than the one the government enacted into law or not? Okay, anyone have any concerns with that?
You know, what you said is unintended consequences, but almost everything has unintended consequences. I mean, sometimes they're actually unspoken intended consequences, and often they're unintended consequences. And how is that dealt with?
Well, I guess I'll clarify that and say, they have to use the least restrictive means possible. So maybe there are some unintended consequences, but the purpose is so compelling, and the government has come up with a policy or law that creates the least unintended consequences possible. Okay, so maybe there might be a few. I'll clarify that. Thank you for that question. So the concern here is that judges are acting as legislators. Okay, they're weighing and considering what is better policy than another.
Mm-hmm.
Okay, as opposed to rational basis, they're not making that judgment call. Okay, government can say any crazy rational, well, I guess if it's rational, it's not crazy, any logical reason, okay, anything out there, even if it's not the best one. And they're not really going to second guess that. So let's go into an example here. So let's say the government passes a healthcare law called the Affordable Care Act that requires employers with 50 or more employees to provide certain minimum healthcare coverage for their employees. Let's say part of that minimum coverage requires employers to pay for all FDA-approved contraceptives, including what some people might consider abortifacients, okay? Plan B, for example. So let's go through this. Is the law compelling? What is the purpose of the Affordable Care Act? to provide better health care for its citizens. Public health and safety is always going to be a compelling government interest. Okay, you can define it broadly like that. Public health and safety, always going to be compelling. Or you could define it as improving women's health. Okay, that's compelling. That's a compelling government interest. Is it narrowly tailored to achieve that purpose using the least restrictive means possible? So what if you're an employer, say Hobby Lobby, and you are owned by Christian adherents whose sincerely held religious beliefs do not allow you to condone abortion. But this law, the Affordable Care Act, which is compelling, a compelling government interest to help women's health, has this unintended consequence of infringing on the sincerely held religious beliefs of the company's owners who have to provide this healthcare insurance. Okay, that's an unintended consequence. But are there less restrictive means possible out there where the compelling interest of improving women's health care can be achieved at the same time, not infringing on the sincerely held religious beliefs of the employer? Is there less restrictive means? Well, yes, there is. Under the Affordable Care Act, the employer can opt out of that coverage, and then the insurance company will step in and provide separate coverage through a government administered system. And that policy was already in place for nonprofit religious organizations. So if that administrative system is already in place, why can't for-profit religious employers take part in that system? So there is a less restrictive means out there. So government, you lose. Okay, the religious employer wins. Any questions on that? This is not supposed to be easy.
Yeah.
Mary, you seem like you have a question.
Well, obviously that has not worked out so well, seeing as how they've allowed right and left all kinds of restrictions on, or restricted reproductive rights through the Supreme Court to religious organizations.
Yeah, I mean,
So-
whether or not you agree with, the court in that particular case, is certainly debatable. But do we understand how this judicial test, this judicial scrutiny is used? Right?
Well enough.
Well, enough. I don't agree at all with it at all.
Well, don't get me started, Mary, on whether that was a
Yeah.
good decision. There's a lot more to it. That's,
Yeah.
corporate civil rights, et cetera, et cetera.
Yeah.
But so you can see if a litigant, a claimant comes forward, the religious employer, and says, hey, you're infringing on my sincerely held religious beliefs, so religious discrimination under the First Amendment, subject to strict scrutiny because it's race, color, religion, or national origin, then the court has to apply the strict scrutiny test. And the common phrase is strict in theory, fatal in fact. So the government's always going to lose under strict scrutiny. So as soon as the court decides if this is a fundamental right or one of those protected categories under the Equal Protection Clause. And then you know, as a litigant, bing, 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 I've already won the case. They've already decided without even applying the test that the test will be applied. So chances are 95% sure I'm going to win just because they've already told me I fall within a protected category or this issue falls under a fundamental right. Okay, bing, bing, bing. So that's why fundamental rights, deciding what is fundamental and not, is so important. That's why deciding what is a protected category under the Equal Protection Clause is so important. Are you going to get rational basis scrutiny or are you going to get strict scrutiny? Are you going to lose or are you going to win? Okay, this is what everyone is fighting over.
So Ryan,
Yep.
You probably have tons more to say, but I'm just thinking, like, one of the fundamental rights is the right to procreate, right?
Sure, yes.
So would it follow that a fundamental right is the right not to procreate? I mean, if it's your decision.
Yes.
So denying people birth control is denying them their version of a fundamental right.
Correct. So I'm sorry.
But it doesn't trump the other piece.
You bring up a great point. And that's why Hobby Lobby is such a good case. This is from 2012, 2014. Because Hobby Lobby brings up so many constitutional and civil rights issues. And one of them is like what you said, what right trumps the other right? Well, the point the judges were making in Hobby Lobby is we're not denying the right of women to access these FDA-approved contraceptives. They are still getting access to them through a separate administrative system. The women don't have to affirmatively do anything different. They don't have to fill out paperwork or anything like that. The employer does. Okay, they can still go to the pharmacy, get their doctor's prescription, go to the pharmacy, get it covered by insurance, and receive the prescription as if nothing ever happened. They would never know what's happening behind the scenes. Now, there's been some spin-offs from Hobby Lobby recently about employers now complaining that, oh, well, now we have to fill out this paperwork. And the act of us filling out this paperwork is against our religious beliefs because we're still allowing the female employee or the male to get abortifacients. Okay, we still have to perform some act that allows an abortion. So we'll see, what happens with that. How attenuated is that chain of causation? Okay, that's being debated. Any other questions on the difference between strict scrutiny and rational basis scrutiny? Okay, one other thing I want to point out, and going back to our dichotomies, at the end, the last bullet point was discriminatory intent versus discriminatory effect. And I think the zoning ordinance is a good example, right? So only single family dwellings for the purpose of preserving the history of the neighborhood. So you notice in that purpose, there's no intent to discriminate based on race, right? We can see on the face, the text of the law, there's no intent to discriminate based on race. Mary, I'm reading your chat. We'll discuss that at the end.
Okay.
So there's no intent there. The intent is to preserve history. How else might one discover what the true intent of a law is? Okay, you don't see it written on the text of the law where we don't want Black people living here. You don't see that written on the law. How else might you discover what the true intent of the law is? So sometimes you might look at what legislators are saying during the legislative debate. Now, there's a lot of debate over whether or not that should be a mode of inquiry, because legislatures have multiple reasons for doing what they do. Some of them, maybe a small minority are doing it for racial reasons, and the vast majority are not, but the law still gets passed. So it's really hard to determine that. And courts, including the Supreme Court, are more and more looking away from that mode of inquiry. But that's one way, sort of stray comment. Okay. We saw a lot of stray comments in 2012 when North Carolina passed its redistricting plan. And there were so many that stating they were doing this to prevent African Americans from voting or having political power that the Supreme Court eventually did knock that down. So there are some times where it just becomes smacks in your face too much. But it's important to know if there's a discriminatory intent or a discriminatory effect, because you will only get strict scrutiny applied to your case if there's an intent to discriminate under equal protection. If there's an effect, an unintended effect, no, you only get rational basis. Okay?
Wow.
That's why intent versus effect is so important, a question to ask yourself when you're looking at a law. Okay? Any questions on that, intent versus effect?
That's helpful.
Okay.
This
Okay.
is great.
So I'm going to go into the third level of scrutiny, but I don't want to confuse you too much. So when you're looking at maybe a spectrum of scrutiny, what's higher, what's lower, just know that rational basis is on the low end and strict scrutiny is on the high end. We're going to now dive into what's in the middle.
Mhm.
Okay.
Intermediate. That's a good term.
Yeah, it's a helpful term at least. Thank you, Supreme Court. So intermediate scrutiny, sex discrimination under the Equal Protection Clause gets intermediate scrutiny. Okay, so remember we talked about race, color, religion, national origin, they all get strict. Sex gets intermediate. And here's the language, here's the test used. The court will invalidate the law unless the government can show that the law serves an important government interest, not legitimate, like rational basis, not compelling, like strict scrutiny, but important, and is substantially related to that government interest. So not rationally related, not using the least restrictive means possible and narrowly tailored, but substantially related. Okay. Again, these are all vague terms. Who knows what they mean? Ruth Bader Ginsburg was instrumental in trying to push this language closer to strict scrutiny. I think she did get one case where the majority said, instead of important, use the phrase exceedingly important. Okay. So whenever sex is involved, that's what we're dealing with. The most famous kind of sex discrimination case for public action, that is government action under the Constitution, was the Virginia Military Academy case from 2000, and well, maybe it was from 2000. Ginsburg did author the majority in that opinion, and that regarded the military academy not admitting female cadets. So some female cadets sued and said, this is a violation of the Equal Protection Clause under the 14th Amendment, sex discrimination. So they went through the analysis of, is this an important governmental interest, and is it substantially related to that end? So what do you think the government's interest was in that case, in funding and running a military academy?
National defense.
Yeah, national defense, military readiness. That's an important governmental interest, right? In fact, it's probably compelling, although that's not the test we would use. And so is denying women entry into VMI substantially related to that end? And the court said, no, it's not. Okay, it's not substantially related to military readiness. In fact, it might do the opposite. Now, why do you think, of all protected categories, sex, why do you think sex gets intermediate scrutiny and not strict scrutiny? Why is it not important enough to get strict scrutiny?
Well, it just seems like it might be threatening to one of the sexes, the guys that wrote the laws.
Is there, okay, that's a very realist answer. I like it. Is there something that makes the differences between the sexes different than the differences between races? Is there a characteristic between these two categories that there's a difference there that makes a difference?
The ability to have a baby.
Okay, we're getting there. I like that answer. Flow with that, follow that. Anyone else?
Race is a social construct, not a biological related construct.
Oh, I like that. So biology, is there a difference amongst the races biologically? What about mental prowess or physical prowess? Is there a difference between the sexes? Maybe physical prowess or mental prowess? I know these are
And if there is a difference, does that matter?
Yeah,
I mean,
does the difference matter? Trying to get back to my share screen. So judges came to the conclusion that the, hang on, trying to get to my share screen. Okay, there we go. Judges came to the conclusion that there is an inherent biological physical difference between the sexes. That hypothetically, we can think of situations where we might need to discriminate between the sexes. As opposed to races, there's no real physical difference where we would need to, physical or mental difference, where we can think of that would create lawful discrimination between the races. But the sexes, sure, we can think of physical differences that make a difference. Can anyone think of any physical differences that might allow the government to lawfully discriminate amongst the sexes? So what about this? Let's say there is a fire district. They have a firefighter's test. And you've got to run up 10 flights of stairs carrying 200-pound bag across your shoulders. And as it turns out, most women, let's say 10% of women, pass the test and the rest fail, while 75% of the men pass the test and 25% fail. putting aside the discriminatory intent or effect, the courts think, okay, well, look, there's a situation here where, we might have to discriminate against the sexes just because of inherent physical biological differences. Okay, whether you agree with that or not, that's not what I'm saying, but that's the court's reasoning for ultimately giving a slightly less level of scrutiny to sex discrimination. Okay, slightly less. Now, I want to talk a little bit about affirmative action, because I think this is an interesting example of how race discrimination and strict scrutiny is applied. So there have been a handful of cases coming before the Supreme Court over the decades regarding affirmative action in state public universities, right? Universities, in some regard, take into account the race of the student applicant, right? Whether you're going to be admitted or not. And so white students over the decades have made claims of, well, this is racial discrimination, a violation of the Equal Protection Clause under the 14th Amendment, and therefore I should be admitted into the school because of this unconstitutional discrimination. And so court said, okay, well, what is this a compelling government interest here? Okay, we're applying strict scrutiny, right? This is race discrimination. And so if you're the white student, you're like, yes, they're considering this race discrimination, I get strict scrutiny, I'm gonna win. So what is the compelling government interest here, do you think? So diversity in education. The court said, yep, that's compelling. That's the government interest and it's compelling. Diversity in education has all these benefits for students. Now, is this the least restrictive means possible? And some of the earlier court cases dealt with quotas or point systems. And so the admissions office would give certain number of points to students based on like, oh, their essay is great. Oh, they had all these extracurriculars. Oh, they are Hispanic. Okay, we'll give them some extra points because we want to create diversity. The rule now is that yes, universities, you can consider race in admitting students, but it has to be one factor among many without quotas and without points. Okay, very hard. I would hate to be in an admissions office at a university. I think it'd be very difficult because you want to and can take into account the race of the student applicant, but you can't assign it a point. It's just kind of a mushy factor you consider. Okay, so that's really what courts decided. They said, you just have to make it a factor, non-numerical factor, and that'll be the least restrictive mean possible to achieve this compelling government interest. So there's affirmative action. This map here just shows states where state government employees or whether the state allows for affirmative action for state government employees. You'll notice Washington voters have repeatedly and very recently rejected affirmative action for state government employee hiring.
And what was the red one? I couldn't read the categories very well.
Oh, let me see if I have it on my. I don't have that on my.
There's red and blue.
Here.
Yeah. Okay.
Legislators, employees. Yeah, I don't know. I'd have to.
Okay. I'm just surprised there aren't more. I mean,
yeah,
that are banned. Yeah.
Yeah.
Okay.
Any questions about these three levels of scrutiny? Rational basis, intermediate, strict. You'll see this terminology, and I'll use it. Heightened scrutiny or lower scrutiny. Heightened includes intermediate and strict. Okay. Anything but rational. Okay, let's get into sexual orientation, gender identity. Okay, under the Constitution, so far there have been a few cases that have come before the court where claimants have alleged discrimination based on their sexual orientation. So far, the courts have applied rational basis scrutiny. Although court watchers, academics have noticed that the court seems to be doing something weird. Although they're using the language of rational basis, they're almost giving it like a rational basis plus, almost a fourth level of scrutiny. And I don't mean to confuse you. Now, the court isn't using that language, rational basis plus, but the only category of discrimination, so sexual orientation, that is winning under rational basis has been claims of discrimination of sexual orientation. Okay, usually the government always wins under rational basis. But so far, the government has been losing under rational basis for sexual orientation discrimination. Okay. Now, the goal of any civil rights movement, there are really two goals. One's constitutional and one is statutory. So constitutional goal of any civil rights movement is to receive heightened scrutiny under the Due Process or Equal Protection Clause. Okay, so that's what everyone's fighting over. When Obergefell v. Hodges came out, they were making claims under equal protection for same-sex marriage as well as due process. Okay, so you can see how sometimes, not always, the Equal Protection Clause and the Due Process Clause can combine into one. So the due process fundamental right violation here was the right to marry. Okay. At the same time, there's an equal protection violation, potentially, of discrimination based on sexual orientation. We saw this combination as well in Loving versus Virginia, right to marry, due process violation, and discrimination based on race, equal protection violation, one and the same. So Obergefell v. Hodges, you'll remember, it was the Supreme Court case that stated same-sex couples could get married, right? Great news, but for those kind of the lawyers, the judges, the advocates who are deep in it, including myself, I was not a fan of this decision. The result was great, but more important than any result in a court decision is the reasoning for the result. Mm-hmm. And the reasoning in the gay marriage decision was awful. Kennedy did an awful job, mushy. We're all sitting here waiting to see if they're going to apply a heightened level of scrutiny under the equal protection challenge. And the court dodged that bullet. They didn't address it. Okay. They just said, under due process, 2 consenting adults have the right to marry who they want, okay, regardless of their sex or sexual orientation. And they gave a sentence to equal protection, but in a vague, mushy way that was not definitive. So it was really kind of a really bittersweet decision, because that holy grail of the civil rights movement had not been achieved. Okay, so watch in the future as cases come before the court and see what gay LGBT advocates are arguing for and why. Are they trying to push that strict scrutiny envelope again? Okay, they keep knocking at that door, and they're going to keep doing it. Okay, so far, let's go back to our dichotomies. We've been talking about government action, public action. We have not been talking about private action, like a private bakery. Okay, everything we've been talking about, judicial scrutiny, all that stuff, that has to do with government action. Okay, discriminatory intent versus effect, government action. When we talk about private action, private citizens, private businesses, totally different analysis.
Wow.
Okay. Preventing private discrimination comes under statutory law, not under the Constitution, right? There's no equal protection or due process issue we have to think about. There's no fundamental right issue we have to think about. And you'll know in Washington state, there are anti-discrimination laws, right? An employer cannot fire someone for being gay, for example. And that's at the federal level now too, under Title VII of the 1964 Civil Rights Act. But where does Congress get the power to pass these anti-discrimination laws? This is where Congress gets the power. Under the Commerce Clause of the Constitution, the Congress has the power to regulate commerce amongst the several states, okay? Interstate commerce. By the 1960s, well, I will say really starting in the 1930s, but really came to the fore in the 60s. This power was expanded. Congress, the federal government, can regulate just about anything through the Commerce Clause. Okay, discrimination affects interstate commerce. So we, Congress, can pass statutes prohibiting private parties from discriminating. So remember I said 14th Amendment is the most litigated part of the Constitution, probably the most important. Arguably the second most important is the Commerce Clause, just because it gives Congress so much power to regulate our lives. We see that in the 1964 Civil Rights Act. Title VII governs employment. Oh, look what I did here.
Wow.
This is a long time ago. I wonder if I remember how to do this. Here's the language. Here's the language within Title VII, prohibiting employment discrimination. And again, I've highlighted the word sex here. We know recently from 2020, sex now includes gender identity and sexual orientation. And now we're seeing a lot of this clash, right? Someone brought up what trumps what rights trump what? And this is now what we're seeing is freedom of religion clashing with other non-discrimination rights, particularly now LGBT rights, okay? Courts have not fully come down on the side of, who trumps who, but I will say in the 60s and 70s, this issue was alive and well with race discrimination. Maybe many of you remember that. The Supreme Court never actually ruled on this issue. There were some one or two federal appellate courts that ruled on this clash between race discrimination and religious freedom, always coming down on the side of preventing discrimination over freedom of religion. So there is some precedent out there that can help the LGBT advocates in their legal arguments before court by comparing themselves to race. Okay. I've got a chat here. Religious freedom ends where it's used as an excuse to harm other people. Oh, Pete Buttigieg said that? Okay. Well, we're debating that issue right now, so we'll find out legally. And remember, religious discrimination does get strict scrutiny. Freedom to practice one's sincerely held religious beliefs is a fundamental right. It gets strict scrutiny. Here's Title II of the 1964 Civil Rights Act, where some states prohibit discrimination in private businesses based on sexual orientation and gender identity. Some states do not. Where's that chat again? If you're interested, if you like maps and you're interested in civil rights, I think the best website to go is to the Movement Advancement Project. Acronym is MAP, fortunately, and they've got all these state maps on each issue. And most advocacy groups rate Washington as the most LGBT-friendly state legally. Okay. So remember that dichotomy between discriminatory intent and discriminatory effect. When there's a government action, we really care about that difference, right? Because discriminatory intent gets strict scrutiny, while discriminatory effect gets rational basis scrutiny. And that's true for every form of discrimination or fundamental right, except religion. Religion, whether it's intent or effect, gets strict scrutiny. Okay, it's the most protected civil right out there, the freedom to practice one's sincerely held religious beliefs is the most protected right out there. And that's because Congress in 1993, with Bill Clinton, passed the Religious Freedom Restoration Act, or RFRA. That said that even if there is a no discriminatory intent, but there's an effect of infringing on someone's sincerely held religious beliefs, we're going to give that strict scrutiny, okay? Now, how can Congress do that? How can Congress pass a law that contradicts the Constitution and judges' interpretation of the Constitution? Well, Congress can provide more rights than the Constitution allows, not less. So they passed a law that gave more rights, more religious freedom than the Constitution required. Okay, so this came about from a 1990 decision, ironically authored by Justice Scalia, arch conservative originalist, in which the state of Oregon and its unemployment benefits division denied unemployment benefits to 2 Native Americans who were used peyote as part of their religious practice in the Native American church, a Christian denomination. And so most states have this law, if you use illegal non-prescription drugs, you don't get unemployment benefits. So these 2 Native Americans sued and said, you know, you're violating my right to practice my sincerely held religious beliefs and religious freedom. And Scalia said, no, there's no discriminatory intent here. And the law is legitimate and rationally related to that legitimate purpose of preventing drug use and only giving state benefits to people who don't do drugs. Well, everyone was up in arms, left, right, ACLU, all organizations, all parts of the political aisle were up in arms. Oh my gosh, that's a crazy, how can that be? Now everyone's rights are going to be infringed. And so the 1993 RFRA was passed very easily by both houses of Congress and signed into law by Clinton. Well, since then, the Democrats have come to regret this law very, very much. And states have passed their own versions of that law as well. These are the states that passed it either through statute or constitutional amendment.
Yeah, Ryan, I'm sorry, I have to do a time check. It's just about 7 already. It's gone so fast.
Okay, I will kind of stop here and stop my tangents. But just know with RFRA that religious freedom is heavily protected because it erases that dichotomy between intent and effect of discrimination.
Right.
There are other laws out there at the state level. Here's one. We already talked about Hobby Lobby, which involved RFRA. And then we've all probably heard of the Equality Act that's been circulating through Congress for 2 decades to extend the Civil Rights Act of 1964 to include LGBT persons. And that's it.
Wow.
Any
Thank you.
questions?
Well, we had the question from Mary, which I know I also found out about your constitutional law course, but I couldn't come to it. So are you doing another one?
Yes, I think it's going to be an annual thing. It's an honors seminar. I don't know if you can audit it. I don't know any of those rules because I'm adjunct. I'm not involved in that.
I was thinking Whatcom Community College. Didn't you do an adult education program there?
I do, yeah. So we've truncated into one evening now, very similar to what you just experienced tonight. But I go more through the Constitution itself. And we do just a little smattering of civil rights. So not as in depth with civil rights as you've got here, but we go more into the Constitution in general.
Okay.
And
Well, it'd be nice. I'd love to find the seminar, but so you do that at Western Washington?
So the honors seminar at Western is a quarter-long course.
Right.
2 days a week for an hour each. There's homework assignments, but if you audit, obviously you're not getting graded or have to do any of that.
Well, I have enough degrees. I don't need another degree.
Okay. And then the one at Whatcom is just 1 night long through their community and continuing education program. So when you get the flyer in the mail that comes out every quarter, you'll see the courses that are offered. And then my Constitution Basics course is one of those.
So what is the course number for the seminar so that I could find out about it?
Let me look up that. And I just put the PowerPoint into the chat so you can download.
Thank you very much.
Let me go through my file here.
This was wonderful.
I know.
Fabulous.
It's very, very mind expanding and just answers a lot of questions, but raises a lot of them too.
So here's the Western courses, Honors 352. I just typed it into the chat. I know there's so many more questions you have now. Obviously, this is a at worst a quarter-long subject matter. And it was,
oh yeah.
So you did really well in an hour and a half. I'm proud of you all. But I want you to understand what rights are and the differences between them, how judges decide the differences between them, and what everyone is really fighting about behind the scenes. And it's that judicial scrutiny level. That's what people care about, because you win or lose based on which one is applied.
Yeah, wow.
It's yeah, we all need more information about it for sure.
Yeah. So that was a feat for you all to take that in as much as you could. Any questions? I don't want to prolong your evening. I'm sure you're all starving, but
Well, I
Go-
just, the one thing you had mentioned, the two holy grails, the constitutional with the heightened scrutiny, and what was the other?
yeah, thanks for bringing that up. So the one holy grail is under the Constitution, getting that strict scrutiny. Remember, that's public acts by the government. And the
Mhm.
second one is private acts by private individuals and entities. So essentially becoming a part of the 1964 Civil Rights Act.
Okay.
Okay, that's the other holy grail. So through the Equality Act, LGBT people are pursuing, both avenues, both holy grails.
Okay.
Okay.
Great, thank you. Yes, Myra, I did record. I started recording a little bit late, but I did record it. So I will, I'll figure out a way to make the recording available to you all.
Okay, wonderful. Feel free to reach out if you have any other questions or want any advice for resources, books to read, anything like that.
Okay, great. Thank you so much. Really appreciate
Yeah, that's really good.
it.
Glad you liked it.
Really, really good.
Yeah, yeah.
It's always tough making it digestible for non-lawyers, so I hope I achieved that. So
Well, you were very patient with us and the examples help a
Yes.
lot.
it's so technical. Yeah.
Uh-huh.
Okay. Well, wonderful. Well, I'll leave it at that, and
Okay,
I hope you all have a great rest of your evening.
okay,
Thank
great.
you.
Thank you. So good to see you again, Georgia. Thanks for joining.
Thank you.